Good evening, everyone. Welcome to our webinar tonight. My name is Jacqui Brauman. I am a Wills and Estate Specialist at SPG Lawyers. And tonight, our topic, well, all our webinars have been so far on succession, but tonight's more about protecting your legacy, how to plan well and how to avoid family disputes. So you have two of us tonight. We also have Tony O'Connor, litigation partner with SPG, my boss. So here he is tonight. He is going to be presenting first. And as a seasoned litigation lawyer, he's going to give you some real world examples and simple oversights that people can make or tensions that tend to explode into costly legal battles, and then how to avoid them. Then after that, I'm going to talk about protecting your legacy. So roadmaps to ensuring your will and your superannuation are protected and how to avoid unnecessary conflict and confusion. So Tony, would you like to kick off?
I will. Thank you, Jacqui, and good evening, everybody. Thanks very much for joining us tonight. Much appreciated. I suppose I'm part of this webinar tonight because I've had many years' experience in litigation across various areas, but one thing that's become apparent in the last 20 years, particularly, and maybe even the last 10 years specifically, is the amount of litigation that is now occurring connected to wills and deceased estates. We're finding in more recent years that lawyers, particularly the no-win, no-fee lawyers, who you might have previously thought were committed only to practice in the area of personal injuries and compensation law, they're now starting to branch out more into those areas. And as a result of that, conflicts are being litigated more regularly. And those lawyers, of course, have a vested interest in trying to litigate and try and make fees out of it. So I'm going to speak tonight about a number of, or three particular areas where this litigation seems to be most prevalent. It's important that I identify those areas because what Jacqui will then speak to you about after I've finished speaking will go some way to giving you guidance or at least guidelines as to how you may protect your own assets and your succession planning and therefore your family. So to start off with, now I'm going to just try and control these slides. I've had a little bit of trouble with this, so let's hope we get underway. I'm just checking here to make sure I've got control. Here we go. I like to start with a quote, and I'll finish with a quote. Oops, we've gone too far there. So, back again. Jacqui, I might have to get you to take control of this. No, we're going the wrong way. Can we get you to... I might get you to take it if you don't mind, Jacqui. Sorry about that, folks. I've had trouble at my end technically today, so... right, so where there's a will, there's a way. We've all heard that saying. A Scottish author by the name of Samuel Smiles. Perhaps we don't know who actually was the author originally of that quote, but it's one that stays with us through history. Next slide, Jacqui, thanks. This is our experience, sadly, that where there's a will, there's an unhappy relative. And this is prevalent more so nowadays, as I've mentioned, because there are now lawyers that are available and willing and ready to take on litigation for unhappy relatives who may feel that they've been left out of an estate, not been left enough out of an estate, or otherwise might have concerns about the manner in which a will has been drawn. Next slide, thanks. So these are the three main areas where things can go wrong. And I'll go through these specifically, but I'll just identify them to begin with. Lack of testamentary capacity. So that's where somebody makes a will and perhaps doesn't have the capacity to know what it is that they're actually preparing or what they're signing. The second area of litigation is lack of proper formality or execution of a will, and that's where the will is not properly compliant with the legislative requirements for setting out a will or has not been signed correctly or perhaps has been signed incompletely. And the third one, which is the most prevalent area of litigation these days, is failing to leave adequate provision for loved ones under a will. So those are the three areas. So we'll run through those one by one. Before I do that, I want to talk about why it matters for you to understand these areas of conflict and subsequently why it is important to get very good estate planning guidance from someone like Jacqui. And these are really our experiences. This causes the estate, of course, to become involved in court action. and court action is very, very costly to the estate. It leaves obviously a lot less to be distributed to the beneficiaries once the court action is over. And that is because if you think of an estate as being a pie, perhaps the size of a pizza, by the time the litigation is finished and the legal rights have been sorted out, sometimes by a judgment of the court, and lawyers have taken some fees out of the estate, and there is some potential for even unsuccessful litigants to potentially have some of their legal costs paid out, as well as the successful litigants, that pie has shrunk down. So what's left to be carved up between the existing beneficiaries is much smaller. So court action is really something you want to try and avoid, and you want to try and ensure that your executors and successors do not have to become embroiled in. The court action is difficult and it can be protracted. Some of these cases can drag on for a significant period of time, sometimes into a year or 2 years even after things commence. And most importantly, it causes extraordinary stress upon loved ones, and it can see discord between family members. In cases that we've been involved in where claims have been made upon an estate, there's been really, in many instances, and perhaps in most, a fracturing of the relationship between different groups within the family or individual family members. And that's often very, very hard to put back together again, even after the litigation is resolved. I've been involved in many mediations over the years, and I can only really recall one instance where at the end of the mediation, and largely as a result of the work of the mediator, squabbling family members were able to reconcile their differences and put it all behind them. Most of the other cases, although they have resolved one way or the other, have resulted in fractured relationships that just have not healed. All right, so the next slide, we're going to talk about here the first main area of conflict or litigation, lack of testamentary capacity. Now, this, as I said at the start, is where it is alleged or perhaps said that a person who signed a will might not have had capacity. That might be because of their age or because of a medical condition or medication that they're on, all sorts of things like that. The courts, when looking at this, will follow an old English case called Banks and Goodfellow. And I've got the 4 indicia set up on the screen there. You can read. This is what the court asks in order to determine whether or not a person had testamentary capacity at the time of making a will. Did the testator, that's the person who wrote the will, understand the nature and effect of the will? Did he or she understand the nature and extent of their assets? Did he or she understand the people who may have had a moral claim upon the estate, that is the deceased estate? And the last wording here is quite quaint Victorian language, but it's still pertinent today. Did he or she suffer a disorder of the mind that poisons their affections, perverts their sense of right, or prevents the exercise of natural affection? So those are the tests that continue to be applied by the Australian courts from that old English case of Banks and Goodfellow. Next slide, thanks, Jacqui. Now, in the context of taking will instructions, a competent lawyer will take steps, and that someone like Jacqui, of course, is a competent, very good lawyer. They will, of course, engage the person in discussion to make sure that nothing seems off in the context of the instructions that are being given. This is particularly so sometimes with more elderly clients who are putting a will together or perhaps updating a will. And apart from taking instructions about what's to go into the will, that person will just be engaged by the lawyer in just some general chit-chat and general banter. And it might be on things such as world events or politics, even sporting events and things like that. And I often use the example, it's a bit silly, but it's not a bad example. If, for example, a lawyer is taking instructions for a will and is just a little bit concerned about whether the person has some capacity issues, the lawyer might engage the client by asking them how they think the Prime Minister is going. Now, if that person were to say to them, well, I think Bob Hawke's doing a great job, well, then we know that we've got a problem. But all that sort of flippant example aside, we did have a case a couple of years ago with one of our lawyers where during the height of the pandemic, the COVID pandemic, an elderly lady was giving instructions and the lawyer engaged her in a discussion about the COVID pandemic, and she didn't have a clue what the COVID pandemic was. So at that point in time, there was a real concern obviously raised. Now, if there is well, I should say, contemporaneous file notes are made of those discussions and we store those digitally. That can be important later if there is a challenge upon the will based on capacity. So that lawyer may end up having to give some evidence about what was discussed and the observations about capacity. If there are concerns, the lawyer may do a number of things, may have some discussions with the client, the testator, on the basis of perhaps going and speaking to the doctor, GP, or in some instances there might be a geriatrician or a more specialised person that might be engaged to get an assessment about whether the person has capacity to give instructions. Sometimes the GP will administer what's called the Montreal Cognitive Assessment Test, which is a general or basic test that's given to a person. It takes about 10 or 15 minutes in a doctor's surgery to determine whether they have cognitive functioning that's sufficient to give instructions. You often hear Donald Trump boasting about the fact that he aces these tests all the time, which is not really much of a boast because it's actually a dementia test. So the fact that he aces that doesn't really say too much. But if there are ongoing concerns, there could be further investigation of medical evidence, and there might even be, in consultation with the client, some discussions with proposed executors or other family members. So those are all the sorts of things that a good and competent lawyer will do. Next slide, thanks, Jacqui. Now, if there are ongoing concerns, as far as the lawyer is concerned, there are options that exist. And again, this might be done in consultation with family members or proposed executors. An application can be made to the Queensland Civil and Administrative Tribunal, which is QCAT, under the Guardianship and Administration Act. And that tribunal has a number of powers, including the power to appoint a guardian for the day-to-day affairs of the person, or in some instances to appoint an administrator to the financial affairs of that person. And that particular person that may be appointed as administrator is often the public trustee, but it can also be a family member or family friend who may have some business skill or experience or some accounting or bookkeeping skill that can demonstrate to QCAT that they would be a suitable person and independently impartial for the purposes of assisting with the administration of financial affairs. If the person has lost capacity altogether and there may be a need to enter into a new will or update a will, in rare cases, the court can make what's called a living will. That's under Section 21 of our Succession Act, which is the act that really binds wills and estate administration in Queensland. A living will is effectively where the Supreme Court can make a will for a person whilst they're still alive, but where they've lost capacity. And there's two things that must be demonstrated. You must show the court that there's evidence of a lack of capacity. That's obvious. Again, this could be dementia, it could be something like a brain tumor or medication that somebody's on. And there must be evidence of what the testator would have done if he or she had capacity. That is, you must demonstrate to the court what is likely to have been the intention of that person had they not lost capacity. We've done a couple of these, not for a few years now, but the last one we did a couple of years ago involved an elderly lady in her 90s who had lost capacity. She had a will. She was part of a family group out in the hinterland that had a lot of assets, particularly a lot of pastoral assets worth tens of millions of dollars. Her current will had left certain assets, significant assets, to her 4 adult children. From the advice of accountants, KPMG, they said that if she were to change her will to leave those bequests not to the children directly, but to their family trust, discretionary family trust, then there could be a saving of capital gains tax of many, many hundreds of thousands of dollars. So we were able to show the court in that instance that had she had capacity, she would have taken that advice from KPMG and she would have changed her will. And as a consequence, the judge did in fact make that order, change the will of that lady to make those provisions per the recommendation of KPMG. And as it turned out, that lady did die about a month later. So we only just got that order in the nick of time. So that was very important. Next one. If it's believed that a testator lacks capacity, a beneficiary or a potential beneficiary has a few options. They can lodge a caveat with the Supreme Court to prevent probate being granted. Now, probate is the process by which the will goes to the Supreme Court to be sealed. Probate effectively means proving. The court proves that that's the last will and testament of the person. So that's what probate is. It's possible for a person, perhaps a family member who believes that the will may be the subject of a lack of testamentary capacity, for that person to lodge a caveat in the Supreme Court to stop probate being granted. We often hear of caveats being lodged in relation to land title dealings. Well, this is similar but different. This effectively puts the court on notice that the registrar is not to grant probate. The caveat must be supported by a notice in writing with evidence of lack of capacity. Again, there might be evidence from family members, there might be evidence from hospital staff, there might be evidence from a GP, there could be evidence from a geriatrician. And then what happens is that the matter goes before a judge for an examination, and the judge will determine whether or not that will should be admitted to probate on the basis that the person had capacity, or whether it should not be admitted to probate and ruled to be invalid because of lack of capacity. If it's ruled to be invalid for lack of capacity, then an earlier will may be admitted to probate if it's proven that at that time the earlier will was undertaken or made when the person did have capacity. Or if there is no earlier will, the intestacy rule applies. Rules apply under the Succession Act, whereby there's a formula in which the will and the estate will be administered according to a list of priorities. And Jacqui will talk about that shortly in her segment. Okay, now the next area. This is the second area which is litigated. I won't speak on this too long. This is fairly brief. Lack of proper formality or execution of a will. Again, we go back to the Succession Act. Part 2 of the Succession Act sets out the minimum requirements for how a will is to be produced and how it's to be signed. Now, if those requirements are not satisfied, the will will be declared or may be declared invalid. The most important features there up on the screen: the will must be in writing. It must appoint an executor or a trustee to handle the affairs of the estate. It must be signed by the testator or the will maker, and it must be witnessed by 2 individuals who are not beneficiaries under that will. They must be independent. So, right. So just go. I think we're back one. Back one, Jacqui. Sorry. Yeah, there we go. No, back again. I think. Sorry. Part 2. Sorry. Can you go next one there? I think we're just missing one there. No. Go back again. Sorry, folks. We're just trying to find the right will here. Right. Thank you. Now, if there is a lack of formality in the execution of the will may still be saved. It is possible for it to be saved. But again, this would have to go to the Supreme Court. Again, more money. That pie is shrinking once the lawyers get their hands on the litigation. The Supreme Court can declare the will to be admitted into probate as an informal will if it complies with Section 18 of the Succession Act. So what does that require? It requires that there must be a document, and I'll come back to what the term document means in a moment, that purports to be under the hand of the deceased. It must be satisfied, the court must be satisfied that it lacks that Part 2 formality. The court must be satisfied that it purports to record the testamentary intention of the will maker. And the court must also be satisfied that it was intended to be the person's last will and testament. There's been quite a bit of development in this area of the law as far as the case law goes in the last few years, particularly on the term document. There have been cases where, in Queensland, for example, where a will that was left on an iPhone, in the notes section of an iPhone, has been admitted pursuant to Section 18 as a formal will. There was some argument about whether that would be a document because it's an electronic document, but in that particular instance, Justice Lyons was satisfied that an electronic recording on an iPhone could be a document for the purposes of saving the will under Section 18. An example of where a will has been saved is a case of Re Omerod, 2022 decision. And that was a young fellow, unfortunately a young man, 29 years of age, who has a cancer sufferer. There was no issue about testamentary capacity, but he made one of those homemade wills that come from the post office. The will was generally pretty good, even though it was a post office will. It was signed, it was properly set out, it appointed executors, there were 2 independent witnesses, they all signed the will in all the right places, but unfortunately the testator, the will maker, the young man, did not sign the will himself. The most important feature you would think. Now, in that instance, the will was saved under Section 18 as an informal will because it passed all those other tests, but most importantly, there were some amendments to the will, and the will maker, the young man, had actually initialed those changes, even though he forgot to sign the end of the will. So the court was satisfied in those circumstances that the will could be admitted as an informal will. Again, it's just a salient lesson that whilst that can be a mechanism for saving a will that lacks testamentary, that lacks formal compliance, it is still a very expensive exercise and takes a lot of money out of the estate in legal fees. All right, so then the third area, and this is the most litigated area, that we find in deceased estates are what are called family provision applications, FPAs. So this is where a will is valid and it's been admitted to probate, but a class of persons who are entitled to make a claim think that they haven't been left enough under the will, or think that or they might have been left out altogether and think that they should be left something. This allows those persons, subject to preconditions and jurisdictional thresholds, to make an application to the court to effectively exercise its supervisory and advisory jurisdiction to determine whether it's considered that the will is fair and reasonable in the circumstances. And if it's not, the court can make changes to the will to perhaps increase a bequest or a benefit to one or two beneficiaries, or perhaps even to allow a beneficiary who's not named in the will to become a beneficiary pursuant to the court order. And I've put up on the screen there what the court uses as it says is its obligation. It is said it is a duty of the court to repair the testator's moral failure. It might be a situation where a father or a mother perhaps has left a child out, but made provision for all the other children, and there's no real circumstances that would explain why that should occur. That would be considered by the court to be a moral failure that the court may feel obliged to step in and repair and to make changes to the will in respect of. Now, the threshold point or the jurisdictional point is that these claims can only be brought by certain classes of people. And they're up on the screen. So it's a child or a stepchild, a spouse, and that includes a de facto, somebody that's been living in a continuous de facto relationship for 2 years up to the date of death, and a person who is wholly or substantially dependent upon the deceased. Now, that may include the parent of the deceased, or it may include a parent of a minor child of the deceased. For example, an ex-spouse. That's quite important, that last point, because even if there's been a separation of marriage, if the ex-spouse is looking after a minor child of the union and is dependent upon, or had been dependent prior to death upon the deceased, they can make a claim. Grandchildren also can make a claim, but only in circumstances if they're under 18 years of age and are being supported. Now, that support, according to a decision of Treadwell and Treadwell, must be substantial support. In other words, grandchildren can't simply, under the age of 18, say, well, I'm a grandchild, I'm entitled because grandma or grandpa gave me $20 every Christmas. That's not sufficient. The court says they must be substantially supported to reach that threshold, that jurisdictional threshold. Okay, next slide. Now, these applications must be filed within 9 months of the date of death. That's pretty strict. In fact, up until a couple of years ago, it was extremely strict. The courts really wouldn't let any applications in outside of 9 months. They are now, the courts, starting to grant some indulgences and some extensions of time in certain circumstances. But again, there's got to be extenuating circumstances proved to the court to bring a claim outside 9 months. If a person is going to make a claim, they need to give a notice of intention to the executors within 6 months of the date of death. Now, to succeed in one of these claims, an applicant has to prove two things, and the courts say these things have to be looked at in cumulative effect. A common need, or a moral need, or a moral claim. Now, a common need is simply defined as a need for some sort of financial support. It can be demonstrated, for example, if the applicant has been left not in a particularly good financial situation in life. There could be any number of reasons why that's occurred. It might be as a result of bad luck. It might be as a result of unfortunate business dealings. It might be as a result of general impecuniosity, or perhaps not being remunerated in a particularly well remunerated field. It might be circumstances where somebody has fallen into ill health and cannot work. It can even be what the courts sometimes unkindly refer to as lame duck applicants. And we've had cases such as this where we've had adult children of the deceased who have been drug addicts. And in those instances, if the estate is large enough, the court can even make provision for them to be given something out of the estate. It might be subject to certain trust conditions, etc. So that's the common need. You've got to be able to demonstrate that you've got the need. You don't really have financial resources or earning capacity and in those circumstances, you need further assistance out of the estate. The second issue is the moral need or the moral claim. Again, as I said, the courts look at these cumulatively. They generally take the view that these things have to be shown together. Now, that can be demonstrated. The moral need can be demonstrated by showing, for example, that the applicant has helped to build up in earlier years the the estate, help mum and dad with the building up of the assets of the estate, or perhaps in later years, there might be a child who has provided love and support and comfort to the deceased in their later years. Perhaps if it was an elderly parent, they might have driven them around to medical appointments and done a lot of things for them, done their shopping for them. Those are the sorts of things that can establish moral need. In very rare cases, the court may find that the claim is made out if both of those things can't be established. And I'll give you a very quick example. There was a decision of the Supreme Court in a case called Quagliata back some years ago. Now, that involved a family with a cane farm up near Mackay, I think it was in North Queensland. And the old father, who was a cane farmer, as an old Italian immigrant, he had a number of children. The cane farm was in trouble, and the eldest boy, Camillo was his name. He was about to leave school and was about to go to the workforce. But his father asked him if he would stay on fairly low remuneration, low wages, to help with the farm for several more years to try and save the farm. He agreed to do that. So in other words, he delayed his entry into the workforce by some years, and he stayed on the farm with Dad and the family to help save the farm. And in fact, they did save the farm. After the farm was saved, Camillo went off to Brisbane, and he had a very successful career, I think, in engineering, and made quite a lot of money. So he was quite a successful businessman. He wasn't in need of money. In other words, the common need couldn't be demonstrated in his case. Years later, the property became very valuable. I think it was bought by developers, or was been eyed off by developers to build house and land near Mackay. The old man died and left very little to the three children, and a claim was made. Now, this is a classic case where Camillo could not establish common need because he'd gone off and had a career independently and made a lot of money and done very well. But the moral need was so strong, as far as the court was concerned, that the judge said, I've just got to award him something, even though common need cannot be established. The moral need is just so strong. And I'll just read you a very quick paragraph of what the judge said, Justice Cullinan. He said this. He said, I am satisfied that the deceased had a moral obligation to each of the applicants, they're the children, to make provision for them in circumstances that I've outlined. Each contributed to the building up of the deceased's estate. That is especially the case with the applicant Camillo. His largely unpaid efforts over a number of years, whilst very young, contributed very substantially to the building up of the cane farming interests of the deceased. So there we go. In that instance, both common need and moral need could not be established, but the moral need was just so strong that the judge felt obliged to make further provision out of the estate for Camillo. Okay, next slide. Now, the other issues that the court will consider in whether or not it will overturn or change the terms of the will and make further provision for other family members. And look at the size of the estate. In other words, the size of the estate is important. If it's a fairly small estate, and even if there's a pretty strong claim by an applicant for a family provision order, the court will be probably reluctant to make any change. I'm often asked, what is a small estate? Once upon a time, I would have said that a large estate was $1 million, but nowadays it's not really, because we know that a suburban house is probably worth $1 million nowadays in most places. The answer would be, I suspect, an estate worth a couple of $100,000 would be considered small, and a court wouldn't be overly interested in interfering with that. There is some talk, or there has been some talk recently, about amendments to the Succession Act to put a $250,000 threshold on these claims. That is to say, you can't bring a claim if the estate is less than $250,000. That has not yet found its way into legislation. It may or may not. But the size of the estate obviously is important. If it's an estate worth $5 or $6 million or $3 or $4 million, that is certainly a sizable estate that would get the interest of the court in terms of exercising discretion to make orders. The court will also take into account disentitling conduct. That is to say, if somebody is engaged in terribly egregious conduct towards the deceased, then the court may rule out their ability to bring a claim. It's very rare that a court will rule a claim out altogether based on disentitling conduct, even if that person was somewhat unkind or cruel to the will maker, to the deceased. If there is evidence that they had been engaged in conduct that was less than kind or helpful, then rather than disentitling a claim altogether, a court may assess what their entitlement might have been, but reduce it based upon that conduct or that bad conduct that the court considers should be taken into account. The court will also take into account estrangement. That is, if there's been, for example, a child who's decided to have nothing to do with the parent for 25 years, and then the court will take that into account. Again, this comes back a little bit to disentitling conduct. That would be an example of it. The court, in that decision I'll put up on the screen there, Freeman and Jacques, Court of Appeal, says that the more exiguous and distant the familial relationship is, the greater must be the demonstrated need. In other words, if you've made a conscious decision to separate yourself from mum or dad for 20 years, you better show that you've got a darn good need if you want us to exercise jurisdiction to give you something out of the estate. And importantly, in the context of these claims, the court has to weigh up the needs of the competing beneficiaries that are named in the will. That is, the people that are named in the will. They themselves, of course, have their own needs, their own moral claims, their own common need, potentially. So the court will absolutely take that into account. Very important. And most importantly is the last dot point there. The onus is on the applicant to overturn the will. The presumption always in these claims is that the will should be upheld, and that's where the court starts from. The judge will say, this will looks valid, it's been admitted to probate, I need to be convinced as to why I now need to interfere with the terms of the will and change the bequests, or to bring somebody else in to give them something that they otherwise have not been entitled to as named in the will. So that is the starting point. But nevertheless, these FPA claims are becoming more common, and they are settling in many instances in circumstances where if they proceed to court, probably an order was going to be made. All right, so to wrap up then, the lessons to be learned. We started with a quote, we're finished with a quote. We know that one. Benjamin Franklin, an ounce of prevention's worth a pound of cure. So get good legal advice on how to set up your will and set up your estate assets well in advance. That's going to save your family and your loved ones from a lot of angst later in life. And it's also going to save your estate a lot of money, because you won't have to come and talk to people like me. So Jackie's the person you want to talk to in relation to these sorts of things. Seek guidance if you believe the mental health of a family member or a friend is failing. Talk to people, talk to family, come and get some legal advice. Talk to doctors, talk to a lawyer about the options that are available. As I mentioned earlier, there are options with QCAT under the Guardianship and Administration Act. And in rare cases, there's options to go to the Supreme Court and get a living will made. The fourth one is probably the most important one I can emphasise here. If you're the will maker, or if you're doing the estate planning, open lines of communication with loved ones about what you're doing, your intentions and your concerns. If there's things that you intend to do, which you think may ruffle feathers later, probably best to have that conversation now, at this time. Speak to people about why you're doing it, the reasons you're doing it, and hopefully get an understanding and an acceptance of that will in advance of your death. That's most important. And the last one is very important too. Continue to update your will, powers of attorney, and other documents as your life circumstances change. We're all a bit guilty of this. I know I am. You do your will or your power of attorney, and it's a set and forget situation, because we all get very busy in life and we forget to look at it and do anything about it. But life does change. Things change. Your children get old. Well, they get older, at least. They grow up. They leave home. Perhaps your health changes. Circumstances change in relation to your career. Your asset situation might change for the better or for the worse. And of course, you might be pending or nearing retirement. So all of those things are very important features in your life. And all of those can be triggers for you to just sit and pause for a moment and think, is it time to think again about whether I need to update this? Do I need to talk to someone like Jacqui and have a quick chat to see whether or not anything needs to be done, just to tighten things up a little bit? If you do that and follow her guidance, which she's about to give you now, I think you can be fairly comforted by the knowledge that it's unlikely you'll ever have to come and speak to somebody like me. But of course, if you do, we're here to help, and we're happy to help. But I hope we don't have to see each other. Okay, over to you, Jacqui.
Thank you, Tony. Just a reminder for everyone, you can find that Q&A button. It's probably along your Zoom bar on the more. If you do have any questions that you want to submit during the webinar, I'm watching those. But otherwise, at the end, we'll take some questions for those who are with us live. So, yes, estate planning is no longer just a will. Our lives are much more complex. And of course, you've just heard how complex litigation is continuing to be and to develop. So when we do your estate planning, we do look at what you own and how you own it. That can be pertinent to deciding whether your will covers your assets and what it does cover and what it doesn't. Because one of our strategies sometimes is, if there is a potential claim against your will, is try and move more assets to be non-estate assets so that it's not open to a challenge through your will. Of course, tax has developed over time and is far more complex. Superannuation is a bigger and bigger asset for more and more people. It's highly regulated, and it's generally not covered by your will. It's got its own separate legislation, and a trustee determines what happens with your superannuation unless you have a binding nomination on that, which we'll cover off a little bit more. Powers of attorney are relevant, of course, because your will doesn't come into effect unless you pass away, but we have more and more situations where we don't pass away suddenly. There's period of injury or ill health, decline in age, or even long periods in palliative care or medication. So powers of attorney can be relevant in those situations. Advanced healthcare directives, if you've got really strong feelings about how you want your health decisions made, if you can't make them for yourself. Trusts. So trusts either created in your will, or many people now have a family trust, or more than one, for growing their wealth. And trusts, assets in trusts are also not covered by a will. So that's another way of passing succession on without it being challenged through a will. And we can also create interesting trusts in a will as well to protect beneficiaries potentially from themselves or from other circumstances. Guardianship, in this context, I'm talking about those people who have children who are still underage. For younger people who are sometimes thinking, well, I don't own much, so why bother doing a will? Well, if you have children, appointing who you want to look after your children can be really important. We don't want situations where orphans are being fought over in family court. It would be devastating, and I have seen that. And we also don't want any doubt around who can be making decisions for children. Aged care. We have new legislation actually coming in on the 1st of November. They're now saying that aged care costs more than raising a child. We potentially are not planning enough for it. We do need to consider it in doing our estate plan, as much as we think that we want to stay in our own homes. And digital assets. Again, more and more our lives are online. We have cloud accounts, we have subscription accounts, we have things all over the place. Most of us don't print photos anymore. We have all our photos on our phone in a cloud. How do we make sure that those can be recovered? And things that we develop, artists, writers, people with IP, how do we make sure that that can be recovered, which is valuable? So before I get into some of the how, this is what happens if you don't have a will. And it is different in every state. So our rules of intestacy, this is found in that Succession Act. So no, it doesn't all go to the government. There are a formula or stages depending on who is in someone's life when they pass away. So if someone passes away with a spouse and no children, it all goes to the spouse. Makes sense. If someone passes away with spouse and children, the spouse only gets the first 150,000, which probably doesn't go very far these days, and then has to share the balance with the children. So they only get either half if there's one child or a third if there's more than one child. I find this really grating. This is the most different bit in each state, actually. And it just doesn't seem like it's enough for a spouse to get by. So if someone passes away without a spouse and without children, so think about a young person who passes away, no spouse, no children, it goes equally to their parents. So this is the biological parent, not the step parent. and it's the biological parents, regardless of whether the child is estranged from one of the parents or not. No parents. So parents have also passed away. Brothers and sisters. If a brother and sister has passed away, nephews and nieces. If it was an only child and their parents have passed away, grandparents. Grandparents have passed away, uncles and aunts. If an uncle and aunt has passed away, their children. So you can see that there is such a huge potential family tree to pull on before anything would go to the government. But still, it would be a mess. And if this happens, there's also no appointed executor. So it is the person who steps forward who has the most interest. And of course, people could have an equal interest, and then there can be issues about who does what. So we don't want to go here. Now, in thinking about doing your estate planning, there are important roles that you should be thinking about. Getting these right help make sure that we don't have litigation issues, particularly executors. We want, and this is when you come to someone like me, you are the one who knows your family and your family dynamics. So we work through that and we work out who is going to work best together, who has the skills to be an executor, who can communicate, who has issues about control, who could create issues when there's no issue. So we want the right people in that role. Beneficiaries can be executors. You can have up to 4 executors at a time. You can have backup executors. You can have backups for backups. Your executors then sometimes become trustees. So this is also a really important role and really crucial to think about what the executor may have to do. So if children or other beneficiaries are having assets held for them, the executors often become the trustee. And so they could be holding funds and investing funds for a long period of time for a beneficiary, and they could have to use a lot of discretion about what those funds can and can't be used for. So you want someone that really understands your values as to whether you would agree for funds to be used for certain things or not. So if you think about children, for example, what sort of extracurricular activities would you encourage and what wouldn't you? Do you think that your child should be bought their first car, or should they have to contribute to that? Is a deposit for a house when they're only 23 a good idea? All sorts of things like that. Guardians, of course, we've covered on already. Really important about who to choose, and the dynamics as well between choosing multiple guardians, which I generally don't recommend, and whether the guardian should be a family member or not. We often think that blood has an obligation, but sometimes our family don't have the same values as us, and our friends actually have closer values to us and may keep your children in a more similar lifestyle than what your family might be able to. Only then do we start really thinking about beneficiaries. So how are you going to divide it up and between whom and in what way? And then we think attorneys as well. So powers of attorney go hand in hand with wills. And I like to think that attorneys run similar to executors, because certainly attorneys making financial and legal decisions have very similar roles as executors. But your health attorneys could be very different, and you can have different people doing different roles and different combinations of how decisions can be made, whether it's jointly or by majority, or whether you have decision making up to a certain dollar value, and then over that value, it has to be a different way. So we have a lot of room to move and get this all right for you. I have a question here, which, how long does probate generally take and what are the fees? Oh my God. So probate, death certificates taking about 5 weeks. Then we have an advertising period of probate of about 3 weeks, and then the court at the moment's taking about 5 weeks. So, you're looking at 3 months at the fastest. And the fees, The advertising and the court fees are about $1,000. And then the professional fees are on top of that, between $3,000 and $5,000. All right, superannuation. As I said earlier, one of our biggest assets potentially, particularly when you look at the life insurance that comes with a lot of the policies that we get. So you think about a 25-year-old, no spouse, no children, been working for 5 years, maybe only has 30 or 40,000 accumulated in super, but has an automatic life insurance policy of 300,000 on their super. So that young person clearly wants that to go to the right people. However, how do they achieve that? So it doesn't follow their will. They probably don't have a will. They probably, and this I see a lot, mistakenly either name their parents or their brother or sister on a nomination when they create their super fund, which is not valid. So we need to get this right, and we do this as part of the estate planning process. However, superannuation is, because it's not covered by your will, can be an interesting non-estate asset that we can also use to avoid claims on your will. So those family provision claims that Tony was talking about, we can bypass certain people and have superannuation paid direct to named people, and it can't be challenged if it's binding. So that's the crucial bit. We have to make sure that it's binding and that it stays binding. Each fund has a different way of making sure that a nomination is binding. So most of the industry funds have their forms online. Has to be a written form similar to a will signed by two people. Industry funds often expire every 3 years. So even if you do one, it then lapses to non-binding after 3 years. So you have to remember to keep it binding. Some retail funds allow you to do a non-lapsing binding nomination. So then it's set and forget. But then you don't necessarily want to set and forget it. You want to review it as well. And if you don't have a binding nomination, it's not the end of the world. Sometimes that is the better situation, because then it often does default back to your estate, and then your will does cover it if you have a will. But it just takes longer, and the trustee of the super fund actually calls for applications to determine who's in the family and who may be eligible, and they work out where and to whom they pay it. And so to whom they can pay it are these list of dependents. So a superannuation fund can only pay super to a superannuation dependent, which is a particular category of people. And that is a spouse, children, or someone who is interdependent. Or then they can pay it to the estate. So those are the choices. Tax dependents are a different category again. So it doesn't quite follow. Some dependents pay tax, some dependents don't. So again, if you're very tax conscious, working through that is a very important part of the estate planning process as well. Coming back to powers of attorney. So there are 3 general types of power of attorney. Every state has a different set of legislation. However, each state recognises each other. Most states have a general power of attorney. Now, we usually don't do this one. All right, a general power of attorney you could do if you were headed overseas and there was a transaction you wanted someone to do, or it's a short-term thing that you're allocating to someone to do something for you. What we're doing with our estate planning is an enduring type of power of attorney. So an enduring power of attorney is called enduring because it endures past you losing capacity, which is the whole point. We want it to apply when we can't make decisions anymore because someone needs to be making decisions for us in that period. A general power of attorney, for example, finishes if you lose capacity. So no one would have power if that's the only one you had. A general enduring power of attorney, covers your financial and legal affairs. In Queensland, it can also cover your personal and health affairs as well. So it can all be in one document. Or you can do the separate advanced health directive and appoint health attorneys in that with detailed instructions. So with your attorneys, we can talk about when it begins. And there's that spelling mistake again, Tony. It's not when it begins. Every time that gets me. So I'm often talking about a power of attorney not beginning until you lose capacity. But in some situations, you could have it beginning immediately. You could have it beginning if you were overseas. You could have it beginning once you hit a certain age. You could have it beginning once you go into aged care. You could have a whole lot of different triggers as to when it begins. You can again have multiple people, up to 4 at a time, usually, just like an executor. And then you can work out how they work together, jointly, separately, by majority, different decisions by different people. So we have a lot of flexibility to get that right. Now, capacity. Tony talked about this really well and covered off the tests that we have, but basically we want to remove that there's any doubt about capacity. So if I ask your friend or family member who you brought along as support with you to come in and help when you see me to do a will because I'm so scary, if I ask them to leave the room, that's part of making sure that you have capacity. And I'm not being rude or anything like that. I'm just trying to make sure that there will be no issue with your will. I need to make sure you can provide me with instructions without help, and that it's actually what you want and someone's not influencing what you're telling me. And sometimes I will also ask you to take a letter along that I prepare to a doctor and get them to fill in a little report for me. And again, that's so that I have it on file to make sure that a doctor has also considered, who has hopefully known you for a while, how your health is and whether there's anything that might be affecting your cognitive abilities. So those are the main things around capacity that sometimes feel a little bit awkward for someone, but rest assured it's making sure that what we're doing for you is as airtight as we can make it. Ways of minimizing risk, which I have touched on here and there throughout, is to consider what is an estate asset and what's not. So some assets that are not estate assets are joint assets. So joint bank accounts, jointly owned homes, things like that aren't covered by your will. So they automatically transfer to the other person that is on that title or on that bank account. Of course, we can restructure how you own things while you're alive. So sometimes that involves transferring something to someone else completely, or sometimes it involves creating jointly owned assets. Sometimes it involves creating trusts, moving things from one place to another, or if there is an existing trust, planning ahead and knowing that as you acquire wealth, do it in the trust instead of doing it in your own name. And I have touched on superannuation, of course, as well. So that is a non-estate asset if we direct it to someone specific. With life insurance policies, some only pay to the estate, some life insurance policies allow you to nominate a beneficiary on it. So that would again avoid the will and go direct to the named person. And there are other financial products as well around that you can have a named beneficiary on that you can only get through financial planners. And then testamentary trusts are an interesting concept as well. There are more and more benefits to testamentary trusts in the hands of beneficiaries, particularly. They won't necessarily avoid a claim necessarily, but if we could, if there was someone that you were thinking of leaving out because they were irresponsible, potentially, or you wanted someone else to manage their money, rather than them managing themselves, testamentary trust is certainly something that I think can be considered. For those who have disabled adult children, sometimes people are just like, well, I just have to leave them out because I'll affect their NDIS and their pension. Well, no, there's other forms of trust that we can look at that wouldn't affect those things. So again, it's what you don't know and all the tricky things that we have access to that we can help through. So a testamentary trust is any trust actually created in a will. But when people rattle off a testamentary trust, we're usually talking about a testamentary discretionary trust. So this is less about protecting your assets from a claim and more about protecting your beneficiaries. So if we're worried that a beneficiary could waste what they get, or that it could become exposed to a claim by their former spouse, or they could be a professional or a business owner, and you don't want it subject to a professional negligence claim or a bankruptcy. You want to make sure that your hard-earned that they inherit is then there for them as a future wealth for not only them, but for their children and potentially their grandchildren as well. Then setting something up that has more of a legacy effect is like this testamentary trust can be for you. So there's asset protection benefits. There's also income splitting benefits. So again, if you're tax conscious, a testamentary trust over time can have quite good tax splitting abilities, depending on the range of beneficiaries that we put in there. So yes, when they're young children, testamentary trusts are well and truly worthwhile considering. Young adults who are struggling to manage their own finances. So sometimes having them learn how to manage their own finances with the help of the executor can be suitable. And then the executors could have powers to step down once they feel like a young adult has learnt enough. And then it can be used for people with a disability, or even for people with drug and alcohol problems, or spendthrift issues, gambling problems. So you can have a testamentary trust benefit a certain beneficiary, but other people in control of it. So how are we going for time? We're getting towards the end, and I really like to get to questions. So I'll just rattle off a couple of these. Marriage, separation, and divorce are really important times to be considering your estate planning. Marriage invalidates any previous will prior to that, unless you've prepared a will specifically in contemplation of marrying the person you made the will with. Separation does not change anything. So if you're married but separated, your separated spouse is still your spouse for superannuation, for your will, all those sorts of things. So for anyone that you are aware of who is separated but not divorced, really important to redo estate planning documents. Divorce is an interesting one. Divorce doesn't invalidate your will. It treats the person you've divorced as if they've died. So you may want them to, but they're not, but the will treats them that way. So they're essentially crossed out throughout the will, and the rest of the will remains valid. The other thing I'll touch on very briefly is the very bottom one there, mutual will contract. So this is something that's been around for a long time, but not used very much, but being used more and more now, particularly with blended families, and particularly because we're living longer. And if someone's worried that, if they die in their 60s or 70s, their partner still could go on and have another relationship live 20 or 30 years more. but you want to make sure that what you want is also done after you pass away. So a mutual will contract locks a couple in essentially to make wills that mirror each other, or that you agree the way that you're going to do things, and you can't change your wills unless you both agree. So of course, if one passes away, you can't then have their consent to change your will. But the most interesting thing about this is that there's been a couple of recent cases which go further and say if there's a mutual will contract and one person passes away, it actually creates what we call a constructive trust over the estate, which protects it from a third party claim later. So if you're potentially worried that your partner will have a third party come in, and even if you trust them, it protects the estate from a third party. Alrighty. Tony, I'm breathless. We are coming to the end of the recording, so I'm going to stop recording now. Our emails are on here on screen for those watching the replay, so by all means email us your questions. But for those of them who are lucky enough to be here live and to have sat through all that, we're now going to end the recording and open it up for you to ask us questions, and we'll hang around for a little bit for you. All right.